Joining us now is Ben Ginsberg. He is one of the most prominent Republican election lawyers in the history of the United States. Among his big cases, he represented George W. Bush in Bush v. Gore litigation in 2000. Mr. Ginsberg was a witness today in the January 6th investigations hearing. He testified as to what it means to actually contest an election on legitimate grounds and the distance between that fairly normal course of events and what the Trump campaign devolved to before January 6th. Ben Ginsberg, I know it's been a long day. Thank you so much for joining us tonight.
Thanks, Rachel.
First, let me just ask about your decision to testify publicly. Obviously, this is a red-hot matter of national concern. There's a very small number of people who are going to be testifying as live witnesses here. Can you tell us about your own decision-making process to agree to do this today?
Sure. Look, there's nothing more important to the American democracy than elections. And for all the years that I practiced law, there were a set of rules and a set of norms under which lawyers would fight really hard for their clients, but always observed those norms. And what the Trump campaign did was completely outside the bounds of the way you can sustain a democracy. He brought more than 60 cases and 187 counts in those cases. And he had his day in court in virtually all of them. Lost some on procedural grounds, but he lost about half of them on the merits. And implicit in being able to have the right to bring those cases is that you have to agree that when you lose, you lose. And there are deadlines in terms of when you bring the cases, and there are deadlines in which the cases are over, and especially on the presidential level, if you don't observe that, it can really damage the peaceful transfer of power, which is what our democracy is built on.
Ben, the other part of my question is what you testified to today about recounts makes clear that a successful recount is in the number of hundreds. Donald Trump lost by thousands in multiple states. He wasn't looking for a recount. He was looking for nullification. What are the ramifications of that?
Well, a nullification is obviously the antithesis of a democracy and people's right to vote being the decision maker on who gets to sit in office. So I think he was looking for the recounts, but he was using the contest procedures to make his what turned out to be evidence-free allegations of fraud and rigged elections. So the important point about all the cases that he brought is that he never came anywhere close to showing evidence, actual evidence of fraud and rigged elections.
Hey, Ben, it's Claire. I want to talk a little bit about all the lawyers who turned down the opportunity to represent the President of the United States and about legal ethics. And what does it say about our profession that Sidney Powell or what's her name, Jenna Ellis or whatever her name was, the clown car of pretend lawyers who ignored the oath they took when they became lawyers and pushed forward lawsuits they knew that they didn't have evidence to support? Why hasn't there been a more forceful rejection of all of these lawyers' ability to practice law?
You know, Claire, I think that the fact that everyone stated, including Matt Morgan, in that responsible law firms would not take on the sort of evidence-free cases that were being brought, and the number of lawyers who dropped off the cases in each of the states as they were filed, and the number of cases that were voluntarily dismissed, said that there is some ethics amongst the legal profession. I suppose you can question the judgment of a few people in any field for the decisions that they make. And I sort of think that's here. But I think the Matt Morgan testimony about major law firms and respectable law firms not being willing to take on the representation because they saw where it was going is really more telling.